All right, hello everybody. Welcome and thanks for being here with us today. My name is Tyler Dahl. I'm the owner and principal attorney of the Dahl Law Group. I have my master's in tax law. I'm also a certified tax coach and a certified exit planner. Big part of our practice here is helping business owners and real estate investors think strategically about tax, legal structure, asset protection, which is why you're all here today, and long-term planning. So really what I do is help people protect what they've built. And so this matters a lot to all business owners. And most business owners are focused on growth, operations, taking care of clients, customers, and all that makes perfect sense. But while they're busy building their business, a lot of things can happen, such as lawsuits, and that these are things that can expose them personally and professionally. So a lot of people assume just because they have an LLC, they're covered, and because they have insurance, they're fine. But unfortunately, that's not true, as we'll discuss today. And so, as you'll see here too, the biggest mistake I see is people waiting too long. If you wait too long, it is unfortunately too late, and there is really, quite frankly, almost nothing that you can do. So that's why today's conversation is so important. Asset protection is most effective when it's proactive. And, as again, we'll see this theme throughout the presentation today. So here again, you are all here to see Asset Protection 101 for business owners, how to protect what you've built. And so as you can see here for the agenda today, we're going to go through why asset protection must be proactive. Again, I just indicated that, hey, if you wait until it's too late, unfortunately, it's too late and there's really almost nothing that you can do. That's because of the Uniform Voidable Transfers Act, which I'll go through and discuss. We'll talk about the role of insurance because that does play a role, but we cannot rely on that solely, okay? We'll talk about exemption planning and then good corporate hygiene and just maintenance strategies. We'll run through a case study and then we'll go through some strategic takeaways. I'll also leave time for some questions at the end for people that may have some questions. So why must asset protection be proactive? Well, first of all, it's all about planning before problems arise, okay? Again, you're operating your business, you're focusing on operations, growth. Everything that you focus on as a business owner or a real estate investor, okay? And, if you're like most of our clients, there's something that's keeping you up at night. It's the danger of a potential lawsuit, anything, okay? Anything that could risk what you've built. And so it's very important to plan before these problems arise because once a claim is foreseeable, most of the planning options disappear. Now, of course, if you're sued and you're being sued and you're served with a lawsuit, well, that's not even foreseeable anymore. That's happening. But, you may run into a situation where an injury happened in your business or something of that nature. And in that instance, we live in a very litigious country. Look, we have more lawsuits in California than any other state in the U.S. In the U.S., we have more lawsuits than any other country. Okay, so it's the most litigious state and area in the entire world, essentially. So at that point, you basically know something's going to happen, right? And I'll go through here and talk about how, like, these other lawyers who sue our clients, that's a business. It's a business in of itself, lawyers suing other people, okay? And so good planning reduces exposure, leverage, and lawsuit value. And there's no magic pill, okay? We can't just say, hey, do this one thing and you'll be okay and protected. It is a whole slew of different tools that we use. And of course, it varies client by client. So the target here is really the goal here, I should say, is making you a bad target for people suing you, okay? It's not necessarily making you invisible because that's basically impossible. There are some tools that we can use that I'll discuss, but it's really making you a bad target or a hard target, okay? When lawyers sue other people, they want the easy money, okay? The lawyers who are suing want the most amount of money with the least amount of work. Okay, so we have those two tools to play with. How do we lower the value that they could recover from you, and how do we make it hard on them? Okay, so let's talk about the too late rule, right? The Uniform Avoidable Transfers Act. Basically what this law says under California is that if you know that, first of all, if you're in the middle of a lawsuit and you got served with a lawsuit, obviously it triggers this law. But if you know that you're going to be sued or have a reasonable suspicion that you are going to be sued, then again, this law is triggered. Now, again, when could that happen? Again, look at this. Let's say you own a construction company and one of your employees is severely injured. Or maybe you discovered a serious construction defect within some of your work, but there's been no lawsuit. Well, you better believe, and you should have reason to believe, that you're probably going to be sued in both of those instances. Okay. Yeah, you're going to be sued, in my opinion, again, here in California. So this applies again when lawsuits are threatened, pending, or reasonably anticipated. And of course, if you don't believe it's reasonably anticipated, there is certainly a lawyer on the other side that will, right? And so the courts look at the intent, the timing, and the surrounding facts related to the circumstance. So what does that mean? The intent, we can't really garner a lot of intent from just the objective, looking at a situation. But if we look at, if emails are subpoenaed and other communications are subpoenaed and things of that nature, then, sure, intent could be found, okay? Intent to defraud, okay? To move assets to somebody else. Certainly, if you look at, hey, you just got sued, just got a $1 million lawsuit, right? And you go and transfer everything you own to your son. Okay, that looks kind of suspicious, right? The intent there looks like you're trying to avoid creditors, okay? However, if it's a sale to a third party at fair market value, hey, maybe the intent isn't quite there, right? That'd be a little harder to argue. Timing is also a big deal too. Again, let's say you get served by a lawsuit, but you get served with a lawsuit today, and tomorrow you go out and transfer assets, right? That's not going to work, right? That's timing. Very shortly after you've become aware of a lawsuit, transferring assets, that's going to be very suspicious. Also, if, like, let's say in this instance, there is some sort of an injury in a job site or something happened within the business that could give rise to a lawsuit. And then again, maybe a few days or even a week after that, you go ahead and make transfers. That's going to look really suspicious. And like I said, the surrounding facts, the courts are generally going to look at everything, all the parties involved, to determine if there was intent to defraud and all that stuff. So one common mistake is freaking out. Okay, like you get served with a lawsuit, a demand letter is sent, and you immediately move assets away from your from in your name, give those assets away. It's a huge mistake that we see. Other than waiting too long, right? I think waiting too long is the biggest mistake. But that could just be one example. Like you get served, you get a demand letter, and then you instantly kind of freak out and instinctively start kind of transferring assets away. So what are the consequences of violating the Uniform Avoidable Transfers Act? Well, first and foremost, the transfers can be reversed by the courts. And so that means you get sued, and then the person suing you claims this was a voidable transfer. Let's say you offloaded all of your assets to your daughter, okay? The courts can go in and order those assets to be returned to you and then provided to the creditors to satisfy any judgments or court orders, okay? And that pulls assets back into your personal estate. And again, subject to bankruptcy, creditors, all that sort of stuff. There's going to be additional legal fees and extended litigation. Generally, it's a separate cause of action, meaning you got to hire an attorney for another matter that's related. So again, attorney's fees attorney's fees rise, and litigation takes a long time. We're talking about years here. It doesn't just happen overnight. So, it's just going to draw things out, right? And then judges are going to become skeptical of later planning efforts potentially. Again, you've done this transfer before, and that could come under scrutiny. The one thing I'll say that's not in here, some of the consequences, if the person suing you argues and is successful in arguing fraud, and other similar causes of action against you, there are potential punitive damages against you, and potentially you've got to pay for the attorney's fees of the other party. Okay, so we're not only talking about paying for your attorney's fees, but other people's, in addition to what you would owe a creditor. So also too, I would warn you here in this situation, if you are being sued and you find an attorney that says, yeah, I'll help you, they are actually going to be engaging in fraudulent activity with you. So a good attorney, if you find a good asset protection attorney, they will tell you this all the time. Hey, if you're getting sued, it's too late, right? Because I don't want to be dragged into any fraud claims as an attorney. And there are other companies out there who aren't lawyers who do asset protection, and where they could be dragged into these lawsuits, but they have no professional license at risk. Okay. So here I'm going to talk about insurance. So asset protection really does start with insurance. Okay. And the reason, so my view on asset protection is, a lot of people will contact our office and say, hey, I want some fancy irrevocable trust. I've heard that those are the best. I've looked at those on social media and that is the best, right? And our view here is, yeah, that could be great in some circumstances, but let's go and attack the cheapest and the easiest to implement strategies first. So that's kind of how we have this presentation set up. That being said, insurance is usually the first and cheapest line of defense, right? Most of the time, insurance is fairly inexpensive. And again, it can cover a lot of things. And so really no asset protection plan can really work adequately without insurance, okay? Again, from a perspective of an attorney suing you, most often when you're being sued, unless you're a multimillionaire, they are going after the insurance proceeds. They sue you, you answer their complaint, and the first thing they're going to ask you, I can guarantee, is, did you have any insurance when this incident occurred? And then they're going to, again, involve the insurance in that. So the attorneys are really looking for the deep pockets because they get a portion of the recovery. Okay, so the deeper the pockets, the larger the recovery, the larger the attorney's fees. They're working on contingency most of the time. So insurance can buy defense, leverage, and settlement power. Again, if you have an insurance policy and you're sued and that insurance policy is triggered, the insurance company has to, obviously after you pay the deductible and all that fun stuff, you have their attorneys that are, defending you, okay? And so, typically they've got a lot of experience. They're pretty defensive of paying out settlements because they don't want to create they don't want people to just know that this insurance company hands out settlements left and right. That can incentivize litigation, and they don't want that. So it's going to be your first line of defense and create some leverage to, again, incentivize the people suing you to, take the policy limits or take, the insurance money as a settlement. So here, I'm going to talk about the different types of insurance policies. Again, insurance covers different risks. From a personal perspective, of course, you have your auto insurance that covers car accidents. You have your homeowner's insurance that covers property. Maybe you've got a policy that covers a rental property as well. And then within the business context, there are a number of different insurance policies, right? We're talking about workers' comp insurance, business interruption insurance, general liability insurance, E&O insurance. I mean, the list goes on, okay? And so the liability covers specific types of risks. Within the personal side, there's less diversity, right? But you may have a different policy for each type of auto you have. For the business, there's a whole slew of different types of insurances that you may need. Now, one thing to keep in mind is an umbrella policy, okay? And so an umbrella policy is kind of like what it sounds, right? You have your underlying policies, auto, home, maybe you have some underlying business policies. The umbrella policy puts a whole nother layer of insurance over the top. And so the covered amount is more. So again, typically you'd have the underlying policies plus maybe like $1 million umbrella insurance policy, which says, look, we'll cover you for the amount of the underlying policies, client, that be you, right? And then we'll also cover an additional $1 million on top of that. And that can be very, very effective in encouraging a settlement by somebody suing you. Again, most of the time they're coming after the deep pockets, which are the insurance companies, okay? Just know that with the umbrella policy, typically these underlying policies have to have higher limits. So the expense of the insurance is going to go up a little bit. And I want to point something out here too, right? I mean, I think a lot of our clients automatically will go to an umbrella policy, okay? And sometimes that's overkill. I mean, if the total amount of exposed assets that you have are less than, $1 million, why would you add, $1.5 million of coverage, right? If you own just a home and maybe a vehicle, it's going to be overkill, okay? If we have an umbrella policy, you get sued, it's discovered, the attorneys are going to start drooling all over that case, right? Because they're going to want policy limits, they're going to fight harder, and that could incentivize even more litigation than necessary. So I think there's a world in which there's a world in which we talk to our clients, we say, look, you have too much insurance, and too much insurance means you're a target, and we don't want that, okay? So the coverage is only as strong as the weakest underlying policy here. Again, these companies are going to make sure that you have a pretty robust underlying policy if you are going to have an umbrella policy. So let's talk about the reality of insurance, though. Insurance companies make money by people paying premiums and them not paying claims. Okay, I mean that's potentially how they make money, right? So I'm going to start at the bottom here and talk about exclusions and exceptions. For all of our clients who have insurance, I say I will strongly encourage you to look at your policy. It's fairly complicated, I know, but you should be able to identify what the exclusions section says and go there and look at every single thing that your insurance policy excludes. What that means is that if any of those incidents occur, you will not get insurance coverage and they will deny your claim. And you'll be very, very surprised at what some of those things indicate. Once limits are exhausted, personal assets are exposed. So again, if you have very small limits, the person who is suing you could say, hey, look, I'm not even going to go after the insurance. I'm just going to go after this person's personal assets. Okay. Or it could be where they could get the insurance money and then try to come after your personal assets. All insurance policies have coverage gaps. So again, if you're covered for $250,000, but it goes to court and trial and the damages are, $500,000, well, the insurance is only going to cover $250,000. Okay. And defense costs can erode policy limits. Some insurance policies are such that you have coverage amount, let's say, of $250,000, and then once your representation by the attorneys begins, you start eroding at that $250,000 because the attorney's fees will decrease that, policy limit. Okay. So there's all these nuances with insurance to be aware of. And again, this is a very integral part of asset protection, because if we don't know these nuances and we don't know these exceptions that can apply, it's going to be really hard to plan against the unpredictable. So here I'm going to talk about exemption planning. And so if you are living and breathing in the state of California, there are certain assets that are exempt from bankruptcy and lawsuits. Okay. So this is in the black letter law of California law. Okay. So the way you think about this is exempt assets are safe. So exempt equals safe, non-exempt, not safe. That's a really good way to remember that. And this is very difficult. And the next slide will go through some different categories of assets. So I guess I'll talk about it then. But we look at insurance, and then what next we look at are exemptions, right? And how do we maximize your exemptions? And what I'm talking about here is if the law says a specific account gets maximum protection from bankruptcy and lawsuits, but you have no such assets, maybe we can divert assets from one bucket, maybe cash, to another bucket, which would be an exempt asset. So we really want to maximize the exemption amount that we have across all assets. I mean, and each asset has its drawbacks that I'll get to in the next slide here. So again, as long as we are not violating the Uniform Avoidable Transfers Act, this is legal, strategic, proactive planning, right? Maximizing the exemptions, exhausting those. And again, this is something that's given to you in the black letter law of California law. It's very, very clear. So what are some common exempt asset categories? Well, 401ks and IRAs and similar retirement accounts, as you'll see in 1 and 2, those have certain exemption amounts. For the 401ks and IRAs, it's generally a reasonable standard. Like, what would you reasonably need during retirement? So again, if you're a person who has a very little amount in a 401k or an IRA or retirement account, and you're worried about being sued, we might suggest putting more money into those. Okay, now obviously we are not financial advisors, okay, but there are certain potential investment, considerations to take into account when you're working with a financial advisor and which of those accounts to put money into. Sometimes those aren't ideal because there are liquidity issues, right? When you put money into a retirement account, there are restrictions on taking those assets out, limitations, restrictions, etc. Cash value in life insurance. So if you have a whole life insurance policy or any other policy that has cash value, there's a certain amount of cash in that policy that can be exempt from lawsuits and creditors. For your primary residence, we have the homestead exemption. This exempts up to about $700,000 of equity in your home, and you get that automatically. Now, we prefer to file a homestead exemption on the title of your property to ensure that if you do sell that property, you have that equity safe for 6 months. Okay. So again, up to $700,000, it doesn't necessarily mean that amount. So when we're doing asset protection planning, we'll look at, hey, what do we think that exemption amount is? Okay. And then again, just note there's different rules in bankruptcy and lawsuits. So for example, one asset may have an exemption limit of, a specific amount for bankruptcy, but a completely different amount for civil lawsuits. So it's a lot of times it's different. And that requires, again, proper insight and planning as to, exhausting those exemption amounts. Here I'll talk about good corporate hygiene. And this is fairly easy, right? I mean, if you're a business owner or you're a real estate investor, undoubtedly you're probably going to have, a corporation or an LLC or something of that nature. The biggest thing I see with these entities is that you've done this online or you've done it in the past with somebody who's not a lawyer, and even with lawyers there's mistakes, and the documents aren't even signed. I mean, I see this all the time. Your documents aren't even signed. You have bylaws not signed, ownership certificates not signed, nothing is signed, and you're not holding any meeting minutes, you're not observing the corporate formalities. And when you're not doing that, and there's a lawsuit against your LLC or corporation, it is much easier for this person to hold you personally liable. So what do we need to do here to practice good corporate hygiene? That is separate personal and business finances. We can't commingle your personal funds with your business funds. We generally can't use, we can't use, your business account for personal use. Another thing is proper capitalization of entities. So when you form your entity, if you put in a very little amount of money, that money you put in is called capital, and it's going to be, again, less likely to protect you personally. Also, if you keep very little money in your bank account, that's going to be much likely for somebody to sue the company and hold you personally liable, because a judge will say, hey, what are you doing here? You have basically no money in this account. You're not really running a real business, okay? Again, as you'll see in the third point down, we need written agreements and operating documents. These need to be signed. Look, I don't care if you're the sole owner. You must have an operating agreement. You must have bylaws. You must have ownership certificates. these documents, if called under scrutiny, are going to make sure that if a judge looks at everything you have going on in your business, they will see, oh, this person actually treats this like a real business. So this lawsuit against that business, I'm not going to let them come after this person personally. And then we've got to have consistent bookkeeping and tax filings. And if you have those, you can stay on top of like the commingling pretty well, right? So again, to summarize on this slide, I just want to say, if you have an LLC or a corporation, you are not untouchable. It's quite the contrary. If you have one and you're not maintaining it correctly, which I would say probably 7 out of 10 people in my experience aren't, and somebody sues that entity, you will be held personally liable. And I can tell you one thing, that it is borderline malpractice for somebody to sue a corporation or an LLC that's a small business and not also include the owners in that lawsuit. Very rarely have I seen an instance where that happens, because you will be sued personally, and they will argue this legal theory, which you can see here on this slide, is called piercing the corporate veil. So how does this piercing the corporate veil work? Again, this is when somebody sues your LLC or corporation, and then a court disregards it. In other words, they say, hey, look, you have this corporation, you have this LLC, and yes, one would think that only the assets in that entity will be exposed, but me as the judge, I'm seeing that you're not observing the corporate formalities and you're really abusing this entity. So I'm going to allow this person to come after you personally. And now you have unlimited personal liability in this lawsuit against your business as well. So again, here, commingling funds is a major risk factor. That's probably the biggest one. So having very clean records as to, why, if a payment looks personal, well, why, right? And having that in writing, okay? I remember one time way back when I used a computer with my personal card, right? And I just didn't have my business card with me. So, again, told my bookkeeper, had it in a written consent, some sort of corporate document saying, hey, look, this is why that purchase was made with personal funds. So again, failure to follow these formalities is going to invite veil piercing and really allow it, okay? And again, if we talk about veil piercing, somebody's gonna be asking for your corporate records. They're gonna be, sifting through those, and we don't really want that, okay? So the result here is, again, that your personal assets become reachable and really unlimited liability relating to those personal assets. Now, here's a concept that a lot of people don't think about. This is called reverse piercing. So I just discussed piercing the corporate veil, and that's when somebody sues your business and tries to come after you personally. What happens if somebody sues you personally, and now they kind of want to reach inside your business and take those assets out? This is called reverse piercing. And again, you can see here, this is when the creditor targets the owner and reaches entity assets. This is really more common in California than you would think. California judges, our public policy here in California is protecting employees and protecting consumers. If you're a business owner, you know that already. Okay, it's a tough life here in California. So the same concepts of piercing the corporate veil apply to reverse piercing. So again, if you need to make sure that you're not commingling personal assets, using company funds for personal purposes, make sure you're holding annual meetings, all that fun stuff. And it's going to make that much lower of a risk. So, and again, having actual signed documents, right? So let's talk about California versus other states. So as I said before, California courts often, have been known to force distributions from an entity. Like, let's say you're a real estate investor and you have an LLC that holds your real estate, okay? And you are personally sued. And we've done a good job of planning in all other aspects. We've got insurance, we've done exemption planning, but this is a particular litigious person and they want more. So California is going to be more likely to say, hey, property owner of the LLC, you've got to take that real estate out and give it to this person who has a judgment or an order against you. And that's where you can see your judges may order the assets to be removed from the entities to satisfy a judgment. Some other states are what we would call charging order only states. Now, what's a charging order? Okay, so let's play this out. You are sued personally, done a good job at planning. Unfortunately, it goes all the way to trial and you lose, and there is let's say a $1 million judgment against you. Okay. What a charging order says is it says, look, I know that you have a judgment against, this person here. Okay. But we are only going to order that you be paid if the person who owns the LLC takes assets out. So again, I own the LLC, I have the property, somebody sued me and got a judgment against me. The charging order says, Tyler, if you take assets out of this LLC, you got to give them to this person that has a judgment against you. I will say that even in states like our preferable state is Wyoming, there's other states that have, Nevada, Delaware, all these other states. We prefer Wyoming. It's inexpensive. The state is generally very pleasant to work with. Unlike Nevada, for example, it's very difficult to work with a Secretary of State. But even in the instance of Wyoming, if you are not adhering to the corporate formalities and if you are commingling funds and doing all those things, there is still a likelihood potentially that a California judge will say, hey, look, I don't care if this is a Wyoming LLC. I don't care about anything. I see that you're abusing the use of this LLC and I'm going to order you to take those funds out. Okay. I mean, you could eventually appeal that and all that fun stuff, but it would be, it could be an expensive endeavor. So, because these states have more protective rights, and you can do this even if you have property in California, you can put it in a Wyoming LLC. Okay, there's some nuances there with registering here and all that, and do you or do you not, right? But you can do that. And the charging order again limits creditors to economic rights only, and that's if you take assets out, you got to give them to this creditor. So layering LLCs can offer better protection. So let's think about this. You have one LLC and that LLC is just owned by you. Okay. Now, if somebody sues that LLC, all they have to do is get through that first line of defense and pierce the corporate veil, and there you're standing. Okay. Now, if you own an LLC that then owns the LLC that owns the property, you have a parent LLC. Okay. If they're going to pierce the corporate veil, they're going to get to that parent LLC and then they've got to do it again. Okay, that can be substantially more difficult. Same with reverse piercing, right? They get a judgment against you, trying to come into the parent company and then down into the subsidiary, which is the company that the parent company owns 100%, is going to be very, quite difficult. Okay, and quite difficult, especially if you're observing the corporate formalities and you're managing it correctly. And for us, through our entity formation process, that's one thing that we're doing with our clients, right? I mean, the documents are fairly the easy part, but what we're talking about is the nuances of registration, taxes, anonymity, and then also the education of saying, hey, look, this is how you need to manage the entity moving forward in order to achieve this asset protection. Another thing to talk about is having groups of properties or assets located in each entity. Look, if we have 10 properties that are worth $1 million each, and all of those are in one LLC, that's $10 million. And let's say there's a lawsuit regarding one of those properties, all $10 million of properties is at risk because they're all in the same LLC. Okay. Now you can have one LLC for every single property, but that becomes overkill if, let's say, maybe you've got, a couple of properties that have a $300,000 in equity, right? Or maybe 10 of those. I don't think I would recommend having 10 different LLCs. That could be an administrative nightmare. And also having an LLC actually increases your taxes a little bit, okay? And there's different costs and expenses associated with that. So that's something that we want to take into account. Furthermore, I would say, we don't want to mix risky assets with, non-risky assets. Like we had a client who had a fourplex in Modesto, which, tenants were kind of, a little risky, right? Not a little, a lot. And then, a home in like Monterey that's by the beach, right? Those are two different risk profiles, and those should never be in the same LLC. Same with commercial properties. Generally, we don't really want to mix commercial with residential because that can be very dangerous as well. So again, the Wyoming parent can enhance privacy too. I think there's a very strong argument to be made that if you have a Wyoming parent LLC, I'm not going to go through it in detail here, but in my opinion, there is a way that you could create some anonymity. So you have, again, a Wyoming parent LLC that owns a bunch of subsidiary LLCs 100%. Each of these subsidiary LLCs have real estate in them, for example. And I do believe that there's a way to do that. You've got to do it very strategically and correctly, and it can, again, increase privacy. And then again, that can be leverage in a lawsuit, right? We recently had a client that came and owned a business and kept getting employment law lawsuits against this client. And they had several properties that are in their name or even in their revocable trust. And it's very easy for somebody to just look at the county recorder's office and say, wow, this person's got a lot of money. I should just go sue them, right? And again, we want to kind of take those targets off of people's backs. And there's other strategies we can employ too, as well as trying to keep things, and I wouldn't say invisible, but less visible. So reduced visibility, increases settlement pressure. Again, a lot of these litigation attorneys suing people they're fairly savvy and and whatnot, but they're kind of lazy too, right? I mean, maybe they'll go to the county recorder, they'll do some limited research, but most of the time they're not really going to hire, like a PI to investigate all the assets you own. That's pretty expensive. So they'll just sue you and kind of push forward and just kind of feel out the situation. And again, if we have the ability to decrease the visibility of ownership on certain assets, that will help leverage settlement pressure. So again, we're not talking about a one size fits all or this one magic pill that's going to protect you. It is a bunch of different options here. Let's talk about irrevocable trust. This is the number one thing I would say people think they need to start with an irrevocable trust. And they're very powerful, but I do believe they're often overkill. And each of these, and there's more types of irrevocable trust. I'm just going to run through these three that are particularly my favorite. So the first one would be domestic asset protection trust. There are various states in the United States that have asset protection trust legislation and statutes, right? So that means that if you set up an irrevocable trust in that state, it is generally safe from bankruptcy, creditors, and achieves the goals, okay? The problem is if you reside here in California and you put a California real estate in a domestic asset protection trust in another state, such as Wyoming, right? A California judge is undoubtedly going to see that and say, hey, look, I'm not gonna abide by the terms of that trust because this property is here in California and I'm sitting on the bench here in California. That is very risky. To decrease some risk, you could potentially put this California property in a Wyoming LLC and put that Wyoming LLC in a domestic asset protection trust. But even then, we're risking a California judge looking at that and scrutinizing it and not respecting it. I think one thing to think about with the domestic asset protection trust are the tax implications, because when you transfer assets to an irrevocable trust, that is either a gift or a sale. And with a gift or a sale, there are serious tax implications. And so you can't just transfer assets into an irrevocable trust and not experience any effect on the tax side. So those have to be evaluated as well. With a domestic asset protection trust, typically if you transfer assets into that trust, I think a very common one would again be real estate or large investments in stocks and bonds and such, right? You can generally still kind of manage those assets in a general sense, but you do lose some control as to the distributions of those assets and some other managerial control. So when I discuss that with clients, a lot of people say, well, I don't want to lose any control. And so unfortunately, this option is not available, right? The other option here is a private retirement trust. California law explicitly, again, in the black letter law, allows private retirement trust. So it's kind of like a retirement account, but it's your own private retirement account. It's not something that is provided through an employer or anything like that. Typically, it's going to be a trust with a private retirement plan. These are dangerous in the sense that you have to justify the assets for retirement, right? So if you just put assets in a private retirement trust, but it's overfunded, meaning there's just a ton of assets in there, and those assets are such that it would vastly exceed what you need in retirement, a judge can poke holes in that, and eventually you will lose some of that. Also, as you could imagine, private retirement trust assets in that private retirement trust have to be used for retirement purposes. So just like the 401ks, just like IRAs and all of that, there's a liquidity problem, and many of our clients don't like that, right? I've got a bunch of cash sitting here, I've got a bunch of stocks and bonds, so you're telling me I can't access those to the fullest extent as I could now? Yeah. Unfortunately, that's a no-go, right? Most clients will kind of obviously would not prefer that. And then the last section here, we talk about bridge trust. So this is a great type of trust. So a bridge trust is an irrevocable trust, and it is an offshore trust. It is set up in the Cook Islands, but it's bridged back to the U.S. for tax purposes. So what that means is we don't have any of this foreign reporting that you have to do, okay? It kind of looks and feels like your typical revocable living trust, okay? There is a limited partnership element. So like the trust owns a limited partnership, which then can own other types of LLCs or assets. Again, every client is case by case, and it's a very overview of, largely an overview of the bridge trust. Essentially how it works is if there's an event of duress, then these assets are then bridged over back to the Cook Islands, back to a foreign jurisdiction where they're very safe, okay? In those jurisdictions, they don't recognize U.S. court orders. So if you get sued here in the U.S., there's a judgment against you. They can't just bring that judgment to a court there, okay? And they would honor that. It would have to be relitigated altogether. There are shorter statute of limitations. That means that they have to bring a cause of action within, I believe it's 2 years, or they're forever barred from doing that. And so this is a very, very, very powerful tool. Again, these trusts are highly effective, but, complex and expensive, I think for some business owners, they're just kind of unnecessary. But again, you don't need to be a multi-millionaire to have one of these, okay? Most of our clients are within maybe you've got five even to $10 million, right? And that's enough, for you to protect it with, for example, a bridge trust, right? Because think about it, if you have $30 million and there's a $5 million lawsuit, that's proportionally speaking, it's not really a lot of what your net worth is, right? Now, if you own $10 million, a $5 million lawsuit is half of what you own. So there's more at risk there if you really think about it. So I would not say that these are just for multimillionaires or really, really, really rich people. I would say, matter of fact, the opposite. And one thing I'll say here too is if you're a business owner and you're thinking about selling a business, this can be a really effective tool, right? Like, I will say probably about maybe 2 to 3 in every 10 business transactions, there's litigation following the closing or some sort of dispute at least, okay? And if you sell your business and right after closing, you immediately set up a bridge trust, and then any post-closing disputes, you can enjoy the protections of that bridge trust, okay? I could do a whole presentation on each and every one of these trusts, and I couldn't even cover everything in an hour. But just know that irrevocable trust, yes, they do have their place. It's not the first place that we jump to. I would think of it more of a building block, right? Typically, we're starting with insurance, doing exemption planning, forming some LLCs. That can all happen within the matter of a few months. Then from there, how do you feel? Okay, you still feel exposed. Now let's talk about a bridge trust, an asset protection trust, all that. And let's also obviously incorporate into there your revocable living trust for probate avoidance, right? Because these irrevocable trusts often will filter back into your revocable trust that you should have for probate avoidance. And with your revocable living trust, there's ways for you to set up asset protection tools for your children in a much more tax efficient way than, again, setting them up right now for yourself. So let's talk about a case study here real quick. We have Alex and Taylor. They own an operating business and commercial real estate that they run the business out of. They have a primary residence and multiple investments and strong income and growth, strong income and growing net worth. And this is before any lawsuit, okay? So if we talk about a business lawsuit scenario, again, the business is sued. Well, the commercial property typically want to hold that in a separate LLC. So let's say they sell widgets, the widget caused harm to somebody. I don't know, it's like a product defect case. Well, it's going to be almost impossible for them to come after the commercial property and come after the liquidity, the equity in the commercial property, because this person never set foot on that property. That property is not in the LLC. We have a rental agreement between the operating business and the LLC that owns the commercial property. Again, there's completely separate entities here. Again, if Alex and Taylor had strong corporate hygiene, then they had their meeting minutes. They didn't commingle funds. That lawsuit against the business, if they tried to pierce the corporate veil, could be shot down by those litigation attorneys defending them. So no veil piercing permitted by the court. Let's think about this too right on here. Obviously, I don't have insurance, but you can imagine, hey, if they had a really good insurance policy, that insurance would kick in. Hey, they've looked at the exceptions in that insurance policy and made sure that specific instances like this that are likely are definitely going to be covered. That's going to add more leverage in this sort of a situation. So let's talk about a personal lawsuit scenario for them. So Alex and Taylor are sued personally. Well, if they're sued personally and we have done a good job at acquiring good insurance and umbrella policy, and we've maximized all their exemptions, and the real estate is held in a Wyoming LLC that is owned by a parent LLC, the plaintiff, the person suing them, it's not going to be readily apparent that they have the real estate. Okay. And I'm talking about, obviously if they have the commercial property too, it could be obvious that they're operating the business from the commercial property, but it's not going to be readily apparent from the county recorder. And what this does is it makes sure that when communicating with these litigation attorneys who are suing you, a card that can be played is, hey, look, our client doesn't really own a whole lot. Our client has good insurance, and it could help leverage a settlement in that way, right? I mean, because if they look and they don't see anything in the county recorder, you can with confidence communicate, hey, they have a lot of their assets are in 401ks and all this. And if you sue our client and you get an order against them, that order really isn't going to do a whole lot for you. Here's why, right? Again, now we've got these attorneys suing Alex and Taylor going, shoot, this was a good case. I thought that we were going to be able to go after the business, the real estate, all that. Or it seemed like a good case at first, and now it's becoming more difficult. They're going to start encouraging their client to settle and probably settle for less money, because again, it's most of these attorneys are kind of churn and burn. They're just get the case, settle it, get the money out, get the case, settle it, get the money out, right? So we're making it more difficult, putting pressure on them to settle the case. And again, as you can see here, we're not doing this with one thing, right? We're doing it with like 3 or 4 different things: insurance, exemption planning, and LLCs. And again, for some of our clients, it probably wouldn't work in this situation with Alex and Taylor. But if we have clients who have a home, a vehicle, and they don't have any rental properties, one thing that we do, because look, that's a risk too as well. We had a case where our clients, same scenario, the client owned a home, a car, and a bank account. This client calls up and goes, I'm scared. My son got in an accident and it was bad. And unfortunately, he wasn't on the insurance policy. Okay. Well, if a situation like that happens, even for somebody who owns those assets, that person's not rich, but there's still exposure there, right? Well, what we're able to do is if we do proper insurance and exemption planning, the communication with the attorney suing them is more of, look, you can sue my client and not take the insurance policies. Or the insurance policy limits. You can deny that or go for more if you want. But just know that if you go for more, my client's going to file for bankruptcy. And if my client files for bankruptcy, here's what you're going to get. And you show them that if that happens, they will get pretty much nothing. Okay. And so that can be very effective too. It's not necessarily effective if you've got, real estate and all those other things, right? Because, the bankruptcy court's going to look at all that other stuff and, be able to sort of take it and to satisfy creditors. So the strategic takeaway here I want you all to leave with is asset protection is strategic planning, not necessarily hiding. I would say decreasing visibility is a big thing. We use insurance, exemptions, and entity structure to work together, along with, of course, irrevocable trusts. And, most protection is achieved without complex trust. And we do some irrevocable trusts, right? But more often than not, I'm having to talk people out of doing irrevocable trusts rather than talking them into doing irrevocable trusts because of the complexity and cost. And again, that's why we start with the basics and the cheaper stuff: insurance, exemption planning, LLC, entity layering, education, and proper corporate hygiene. And then we do sometimes go to irrevocable trust, but we like to start there. And so again, planning early creates leverage when it matters most, and you don't want to start this when it's too late. If you have reasonable suspicion you're going to be sued, or you've been served with a lawsuit, or you receive a demand letter, it is already too late, and any reputable attorney will not be able to help you. And you don't want to be accused of fraud. That is not good. I want to avoid the F word, right? So that's it for right now. If you want to contact us, we do, just go ahead and submit a form, or go ahead and scan this and submit a form on our website to set up a time to meet. So that is it. If you're sitting here thinking you're not sure how protected you are, or you're just doubtful, now is the time to act, right? And I think if we're able to sit down with you and talk about things and show you how exposed you are, that's going to bring you a lot of peace of mind. And then again, obviously, if we do the planning, you're going to get a tremendous more amount of peace of mind. So I'll leave it up to questions right now. So the first question here is this only for high net worth business owners, or does it apply to, it applies, as she said, is this only for high net worth business owners, or does it apply to smaller businesses too? This applies to everybody. I think, again, my view is that if you own a business, the less you have, the more you have to lose. So if you own a business and if you have any net worth, ask yourself, am I okay losing it all? And most people are going to say no, right? And if you don't have a lot of net worth and your answer is, yeah, I don't really care, I don't have a whole lot, yeah, then maybe it's not for you. But I'm willing to bet that nobody looking at this webinar and viewing it is in that situation. So when does a claim become foreseeable? So like I said, a claim is going to become foreseeable when an event occurs that a reasonable person would think they're going to be sued. Again, we're talking about an injury on the job from an employee, or a customer slips and falls, or there's some defect in the product you discovered, or you just got served with a loss, or you received a demand letter. All of these instances are going to create a foreseeable standard that a judge is going to look at and go, hey, you should have known, you knew darn well that you were going to get sued. Next question here is, how do courts decide whether a transfer was made with bad intent? So yeah, they'll look at the facts and circumstances. Again, they'll look at the timing, how quickly before or after the incident did you make the transfer, to whom did you make that transfer? Was it a gift to a total stranger? Was it a sale of assets to a total stranger? Was it a gift to your family member? They'll look at all of those things. And unfortunately, I don't have an equation that you can follow, or a roadmap you can follow to make sure that you're not doing it in bad intent, but it is a facts and circumstances type of test. How often should I review my structure and insurance? I think it's probably a good idea to review your insurance every year. Look, you've got to renew your insurance every year, right? So it would warrant you taking a look at policy limits, exclusions, and evaluating that. The structure, I would say whenever there's an acquisition of an asset, let's say you're a real estate investor and you just bought another piece of real estate, right? Probably get a jump on the phone with your attorney and say, hey, look, where should I put this one? Which LLC should I put it in? Should I get a new one? What should I do? Any large increases in value of your business would warrant more planning in future, maybe structural changes. So I would say, acquiring assets, large increase in value in assets, and then just that's for reviewing the structure. And then every year you should be reviewing your insurance. And where should a business owner start first? I would say schedule a consultation with us. We have a strategy session. It's $750 for 1 hour. We'll talk about asset protection, tax, whatever you want. And we'll go through and come up with a strategy, right? Whatever is on your mind, we'll go through and again, come up with a strategy for, again, asset protection, tax, everything. We have that $750. If you do hire us, all our planning is flat fee. We credit that $750 to the flat fee. We do basically have a money back guarantee. If you feel like you did not learn anything, we will give you your $750 back. We're so confident that what we are going to go through is going to be very valuable to you. So start with scheduling a consultation with us. If you're not ready to, I get it. We have a lot of blogs on our website. I think start doing some research. But look, you're never going to get, if you're not a lawyer who focuses on this, you're never going to get the level of education and knowledge that you would with an hour with an attorney, right? That's going to be just immensely valuable. So see if there's any other questions here. It looks like that's pretty much it. All right. Well, I want to thank everybody for joining today's webinar. Again, just at the Dahl Law Group here, we're in a relationship-based law firm. We're really not about helping people and then just disappearing, okay? So we do tax preparation, tax filing, tax strategy, estate planning, asset protection. We help our clients with business law compliance, everything, right? I would say instead of you going to 5 different people who are going to tell you 7 different things and none of them agree, and oh, by the way, you have to be the middleman or middlewoman explaining all these things to the professionals, you can come to one place where we have a comprehensive, integrated strategy to everything and explain why are we doing these things, okay? And then also have accountability built into this, because a lot of times if something goes wrong, we have advisors pointing fingers at each other and nobody's taking true accountability. Well, when you have one person doing everything, there's only one place to point fingers, okay? And that generally doesn't happen here, but I think that's should be peace of mind for all business owners, knowing that, look, I've got one firm that has my back and can provide this advice in a comprehensive, integrated way. So thanks again for joining, everybody. Stay tuned for other webinars that we do have. We will be doing many other webinars on other topics related to our practice areas. So look forward to seeing you all there, and I hope to see you soon.